So I hate to interrupt everyone's conversations over lunch, but I bet you will be happy to know why I'm interrupting, which is to introduce Professor Jack Goldsmith from Harvard Law School, former Assistant Attorney General in OLC and former almost everything else, one of the nation's, I think, foremost authorities on executive power, national security, and related issues. And I'm just going to turn over the floor to him. Thank you, Jack.
Thank you, Michael. Thank you so much for inviting me here. Thank you to the Con Law Center. Thank you to Morgan very much for helping me with many issues. 3 days ago, I emailed Morgan and I said, can you all hear me? I emailed Morgan and I said, I've got some slides. Do you think I'll be able to use them? And about 30 minutes later, she writes me back sheepishly and she said, well, we're going to have this outside, but I guess we could move it inside if you really wanted your slides. And I said, definitely not. And I'm glad I didn't. So maybe the talk would have been clearer and easier to absorb if there were slides, but this is a beautiful, beautiful environment. I've never spoken outside like this with the party in the background. So anyway, my topic today is the institutionalized special counsel. I'll tell you what I mean by that in a second. The last panel was about prosecuting presidents, and at the federal level, if a president's going to be prosecuted these days, it's going to be by the special counsel. Jack Smith is the special counsel that Merrick Garland nominated to investigate, and then he made the decision to prosecute Trump for 2 sets of crimes. By institutionalized special counsel, I mean the special counsel. So we've had special counsels, as I'm going to talk about in a moment, going back to 1875. By institutionalized special counsels, I mean counsels that are lawyers that are appointed by either the Attorney General or the President pursuant to some freestanding regime that governs the authorities and limitations on the special counsel. The key point being that the special counsel is in some sense independent of the Attorney General. There were 2 basic regimes of institutionalized special counsels. The one was the Ethics in Government Act Independent Counsel Statute, as it was later called, from 1978 to 1999. And then the second was from 1999 to the President. Those are under Justice Department regulations. That's the institutionalized special counsel. And this special counsel is supposed to ensure that the Justice Department can credibly and fairly conduct sensitive investigations of senior executive branch officials. The basic idea is intuitive. The Attorney General can't be trusted, since the Attorney General was appointed by and so close to the President, can't be trusted to conduct a credible, independent investigation of the President. And so for political reasons, for the appearance and reality of justice, we need to appoint someone independent of the Attorney General to conduct the investigation, and that will help enhance the credibility of what happens, preserve the Justice Department's independence, and preserve the fair-mindedness of the Justice Department. So, in my view, the institutionalized special counsel has failed, and failed badly. That's what I'm going to talk about. And one way of seeing the failure is that it's now reached a crescendo. We have 2 special counsels, Her and Smith, who are, if you read the front page of the New York Times in the last 3 or 4 months, there's at least as much about the Justice Department's impact on the election as there are on the substantive issues in the election on the election. Arguably, the Justice Department, with Her's comments in his report on Biden's state of mind, and Smith's, what I think is a rush to prosecution of Trump, these 2 men, independent counselors, are going to have potentially a huge impact on this election. And I think that at least highlights what the problem might be. And I'm going to argue basically that I think we'd be better off if we just got rid of this institutionalized special counsel and had all investigations of high-level officials take place within the normal channels of the Justice Department. The argument is, there's a counter-argument. I'm going to flesh out the counter-argument. I'm not really sure what the right answer is, and I'm not really sure whether if we got rid of the institutionalized special counsel, anything would change. I'm also going to talk about that. I'm going to use special counsel to cover the whole period, including what used to be called the independent counsel, and I'll talk about these different regimes in a moment. My argument is not a constitutional argument. It's not an argument based on Article 2, because what's going on now all takes place fully within Article 2. There was an Article 2 challenge to the earlier statutory regime, but now the regime we have is one purely created within the Justice Department, within the executive branch, and I don't think that it raises constitutional questions, although it raises constitutional values, you might say, questions of constitutional value. My argument is basically going to be consequentialist. I'm going to argue for what I think is the least bad regime for investigating, all things considered, for investigating high-level officials and especially the president. There are going to be a whole lot of normative assumptions, and I'm going to make a lot of counterfactual claims along the way. It's a short talk. I can't defend it all, and I'm happy to try to defend it afterwards. Okay, that's where I'm going. So there are three key periods in the history of the special counsel in the United States. The first was what I'll call the non-institutionalized special counsel. This was for the first 190 years or so of the Republic. We had, I think, seven investigations in which either the president or the attorney general appointed an outside prosecutor of some sort to investigate alleged corruption at the highest levels of the executive branch. It started in 1875 in the Grant administration, and the tail end of this period was Watergate in 1973, which was the last what I'm calling the non-institutionalized special counsel. Just a word on Watergate. So in other words, we had special counsels even before we had statutes and regulations about special counsels. And these arose because of the felt political imperatives of the executive branch that they needed to have a credible investigator to investigate high-level corruption. Just a word about Watergate, because Watergate, I think, has been so misleading in our understandings of the possibility of independent special counsel investigations. So Watergate is the great heroic success where the virtuous independent counsel, with what came to be large bipartisan support and huge national support in the country, uncovers extraordinary corruption in the executive branch and brings down a president. And that's all true. But it's a misleading example for a couple of reasons, at least for our modern times. First of all, it might not have turned out that way. We don't remember this. We think now of special counsels as being subject to heavy partisan attack, and that's part of the problem with them. They become delegitimized in a highly partisan context. Archibald Cox, when he first got going, was subject to many of the same political abuses that Ken Starr was, and Judge Walsh, and Robert Mueller, and all special counsels. Cox was thought to be he was accused early on of engaging in a partisan witch hunt against the president. And the evidence for this was he chose a bunch of well-known liberal lawyers, including his top 11 officials in his office were officials from who were close aides of Robert Kennedy and Bobby Kennedy, Nixon's mortal enemies. And he was being attacked as being a partisan and as being too aggressive and the like. That all dissipated. And it all dissipated because mainly the Saturday Night Massacre, when Nixon fired him, which Nixon said in his memoirs was a monumental mistake, and also because he uncovered, and his successor uncovered, so many smoking guns, and because of the combination, I think, of the Saturday Night Massacre and then the success of what was uncovered, there led to a consensus that this was the right thing to do. But there's never been such a consensus since in any of these high-level investigations of presidents. So it's an important precedent, but I'm not sure it's a representative precedent. So that's the end of the first period. The second period is the one from 1978 until 1999, the Ethics in Government Act. This was a statute enacted after Watergate to institutionalize by statute an independent counsel. I'm going to be very brief, and I'm happy to talk about this more in detail if you want. The idea was that a court would appoint, that we need to have someone out. We can't trust the Attorney General to appoint a special counsel, that a court, a special division of the D.C. Circuit, I think it was, outside the executive branch had to appoint the special counsel. There was a very low bar for the appointment of a special counsel. Removal was for cause. There was a requirement to send a final report to the judges, and also a provision that the independent counsel, as it came to be called, could send an impeachment report to Congress. There were 24 investigations, a little over one a year during this period. There was a little 2-year lapse in the statute, and I'm ignoring that, but there was 24 investigations, one a year, a little over one a year in this period, 1978 to 1999. And the statute lapsed in 1999, and at the time, there was extraordinary bipartisan consensus that this was a disastrous mistake. And I just reread the hearings that led to this in the last week. And I'm not saying that everyone who testified in these hearings said that this was a disastrous mistake, but the majority view among Republicans and Democrats, former special counsels and others, was that this was a mistake. And these were the consensus points, the takeaways as I see them from why the special counsel statute was allowed to lapse. One, something that I can't remember if it was Sy or David. David, I think, focused on that in the last session, that the problem with the independent counsel is this person is giving unlike every other prosecutor, which has budget constraints and has to make trade-offs and has to work within a bureaucracy, as David talked about. The special counsel was basically on his or her own. They were focused on one person. They were kind of charged with finding something, or at least they perceived the job that way. They had practically open-ended budgets. Their incentives were to find their catch. And they did not have to engage in the various types of trade-offs, both budgetary and resource, but also thinking about considerations that I'll talk about more later about community interest and broader concerns. They didn't have to engage in these trade-offs. So that was one point, was that that's what happened. The second consensus point was that this led to zeal and norm breaking and excessive investigations that went on too long and dug too deep and made inappropriate prosecutorial and other decisions. I'll give you the two most famous examples. One was the Walsh Whitewater investigation, which led to, Iran-Contra investigation, in which he, among his other controversial things, issued a final report that was full of something the Justice Department would normally never do, uncharged allegations against a whole array of officials, stating somewhat contestable propositions. He also indicted Caspar Weinberger, one of George H.W. Bush's aides. I think it was 4 days before the 1992 election, which was seen to be very controversial at the time. Many people thought that, of course, the Bush team would say that's what caused them the election. We can never know that. But this charge was dismissed, I think, a couple of weeks later as an inappropriate charge to have been brought. That's not something the Justice Department normally would have done. So these are just two examples, and there's much more I could say about those examples and others. Not every one of the 24 had this problem, but it seems to be there's a correlation between the higher up the fish, the more excessive the independent counsel. The final report and the impeachment report were thought to be bad things because they were just opportunities to put all the stuff that the special counsel found, including uncharged allegations that weren't relevant to the criminal determination, and these things get laundered in public, which both make the special counsel seem maybe more political and just feed into the political frenzy that Congress uses these reports to basically try to bring down the people who were exonerated but nonetheless criticized. It came to be seen, and again, this is my summary of a 2,000-word document, so some of you might not agree with some of my emphases. It came to be seen, independence came to be seen as a bad thing. Independence came to be identified with rogue. And this was even before our current era of politicization. And the idea was, the core takeaway, as Janet Reno said when she testified, she was the Attorney General, is the problem here is that the accountability and the responsibility needs to be grounded in the Attorney General. That is the constitutional officer that needs to be making these decisions. That was the big takeaway. And of course, because of all of these problems, the very sharp partisan attacks that these special counsels attract, they had traction. They had traction. There was, the partisan attacks had plausibility on both sides, Republican and Democrat, depending on whose ox was being gored. Okay, so those lapsed in 1999, and they were replaced by a regulation, not a statute. So this is not something by Congress. This is something the executive branch does itself. And these regulations aim to fix the statutory scheme by supposedly doing what Reno said she was going to do, placing the responsibility for these decisions in the Attorney General. And in a moment, I'm going to explain in a little bit more detail why I think that's so important. And so the regs did give the Attorney General, the person who's in charge of prosecutions for the government, who exercises the President's delegated executive power. It did give the Attorney General much more power in controlling special counsels. It gave the Attorney General the authority to appoint a special counsel pursuant to a set of regulatory criteria. It allowed the Attorney General to overrule unwarranted or inappropriate investigative steps. It allowed the Attorney General to remove the special counsel for listed bad acts, and it gave the Attorney General the power to control the budget. And that sounds like it's kind of responsive to the problems in the independent counsel statute. It also eliminated the impeachment referral, and it also tried to tamp down the reporting requirement, which was a source of extracurricular prosecutorial activity, by saying that the report would go to the Attorney General, and the Attorney General would determine whether to release the report. So it would be the Attorney General's responsibility. So this statute is still in the books. It's been going since 1999. There have been 7 investigations. There was one in 1999 over the Waco matter, the first one. Then the next one, and then there was one in 2003 when I was in the Justice Department, and this is something I'm just going to mention and bracket, and if we have time to talk about it, I'm not sure I'm going to. If we have time to talk about it, I will. But this was a special counsel. Fitzgerald was appointed by Deputy Attorney General Comey to investigate the yellow cake plame scandal about the leaking of the identity of a CIA agent. He wasn't even appointed under the regs. He was appointed pursuant to a background statutory authority of the Attorney General, and he was given a different set of independence. But the point here is the special counsel regulations don't even necessarily have to be applied by the Justice Department. It's actually an important qualification. I'll come back to that in the end. In any event, not much happened under these regs. There was the 1999 thing. There was the 2003 that I just talked about, which wasn't even about the regs. But then we've had 5 in the last 7 or 8 years. We've had Mueller doing the Russia investigation. We have Smith doing the 2 events for the classified documents case and the January 6th case. We have the classified documents investigation of President Biden. We have the Weiss investigation of President Biden's son. And finally, we have the Durham investigation where Attorney General Barr nominated Special Counsel Durham to investigate the investigation of the prior administration. So those are the 5 that we've had in the last 8 years. And look, you can't tell much from these numbers, but I'm not going to say that there's a powerful trend now because we've had 5 in the last 8 years, but we've had 5 in the last 8 years. Okay, so here's the first perhaps interesting point that I'll make, and that is the main problem with the special counsel regulations is, despite all of the changes, is it replicates essentially every one of the consensus problems under the Ethics in Government Act. Practically unlimited budget, and let me just say at the outset, the reason that it replicates the problems is because the Attorney General, this is my view, it's my interpretation of events, the Attorney General is either too weak-willed or afraid or cautious about exercising his or her accountability measures over the special counsel for fear, because we have this massive independence norm that I'm going to argue in a second is not useful, for fear of unduly interfering with the special counsel. So that's the kind of master norm that proceeds through the special counsel regulations. So the Attorney General has budget control over the special counsel that he never exercises. So we still have practically unlimited budgets. We still have the same problem of the special counsel being nominated to focus on one individual or one set of individuals, have incentives to, the special counsel wins when the special counsel finds something wrong with the person targeted. The special counsel does not have to engage in the normal trade-offs that prosecutors do. So that part of the EIGA problems, they persist. As a result, I think, and as a result of inadequate supervision by the Attorney General, the zeal and norm-breaking and excess and violation of DOJ norms persists. And it persists just as it did with Starr and Walsh, who were highly respected lawyers. It persists with highly respected lawyers during this period as well, which suggests, if I'm right about the zeal points, you might not agree with me, suggests that the problem is not with the personal, it's some structural issue here. So, for example, Bob Mueller, in my opinion, did three things that were pretty clear departures from what a normal Justice Department prosecution would do. He declined to make a prosecution or declination decision, even though the regulations strongly implied that he was supposed to, and even though the Attorney General thought he was supposed to. He said he wasn't going to do that, in part because he said he wasn't allowed, because the president himself couldn't be indicted while in office. Mueller also made very clear, this is something that a prosecutor never would have done, to say, even though we're not charging you with a crime, we're not saying that we're exonerating you either. That never would have happened. I've never heard that ever in a Justice Department context, except perhaps in the Jim Comey-Hillary Clinton matter, which has its own problems and is not unlike this situation structurally, if you want to talk about that. And also, in my view, I've written about this a lot, Mueller did not follow the appropriate, the OLC opinions appropriately in discussing the charges that might have been brought against Trump. John Durham's final report was, in my view, legitimately criticized because he went far beyond his remit to determine criminality and made all sorts of just critical comments about all sorts of practices that had taken place during the investigation. And to make it worse, he didn't add much to what the Inspector General had already said. It wasn't the usual declination decision. It was basically an attack on the previous regime. That's the way I read it. The Biden special counsel, was widely criticized for including all those remarks about the president's mental state and the like in his report. I'm not so sure that Hur deserves the criticisms he's given. His report reads like a typically candid, if not too long, declination decision that happens all the time, that prosecutors do all the time, that stay in a drawer somewhere and nobody sees. The problem is, I don't know what Hur's motives were, but he makes these extremely candid remarks about the president's mental state that are foreseeably going to be very damaging to the president, and he knows full well that this report is going to be published because Merrick Garland, even though he has discretion not to disclose it, and even though he might have had discretion to make him change that, didn't. And Garland published this, so many people thought that that was a violation of DOJ norms. And Smith has not yet issued a report, but in my view, some of you may disagree, it seems pretty clear to me that Smith's extraordinary rush to trial for Trump is almost certainly motivated. I can't read his mind, but this is what most people thought until I started making this argument, and then they started coming up with other reasons why he might be doing it. It seems that the obvious reason that he's rushing is he wants to get this evidence out before the election. There are other possible explanations, but that's something that's clearly not allowed by DOJ regulations. Okay, also, the three reports, 400-page reports, full of all sorts of details that are extraneous to the criminal determination, all of which are, in all of these reports, politically very political red meat. And of course, Congress takes the red meat and runs with it, and politicians take the red meat of both parties and run with it. These special counsels go up before Congress and they spend the day, and they're basically poured over by both sides, all of this has the impact of making the Justice Department seem the opposite of what the special counsel set out to do, which is to inspire public confidence, to make the Justice Department not seem political in its decision-making and the like. And basically what's happened is, and this was true in the Ethics in Government Act, and it's also true in the special counsel statute regulations, is that special counsels have adopted what Michael Rappaport calls the accountability function. Rappaport distinguishes between the criminal function of the special counsel, which is to determine whether there were crimes, full stop, and if not, you go about your business. That's what the Justice Department normally does. The accountability function is that the special counsel's job is to uncover facts, find out what happened, get a complete record of what happened in some controversial context so that the public and Congress and the press can know and hold the president or some other accountable. And again, we can debate about this if you want, but this is not obviously a proper prosecutorial function, and this is what the special counsel has largely become. I said I go 25 to 30 minutes, I'm almost done. So here's one proposal. End it. Just destroy the regulations. Ensure that all high-level investigations are fully under the supervision explicitly of the Attorney General and make the Attorney General accountable for everything. The old regime replicated the problems that in 1999 we thought were very bad. There's a question whether, one argument against this is, well, if you think the politics are bad when a special counsel is doing this in terms of attacks on the Justice Department, they're really going to be bad if it's under the supervision of the Attorney General. I'm not sure that's true. I can't do that counterfactual. It's not obvious to me that that's true, but maybe it's true. That might count as something on the other side. Here's the most important thing. I think that if the Attorney General is in charge and is truly supervising these investigations, that we're much less likely to have what I call these norm-breaking instances of excess and zeal. And it's important to remember that, the Justice Department sometimes gets on its high horse about the importance of independence and the importance of enforcing the rule of law, as if that's some sort of algorithmic process. The Justice Department is not in good standing in this country right now for very good reasons. They've made a lot of mistakes over very many administrations in not following their rules, and special counsels contribute to this enormously, and this strikes me as a do no harm principle. This is the first thing the Justice Department should stop doing. And I think, if you can still hear me, I think that if the AG were making these decisions, all the decisions I just described, instead of the special counsel, that we would see a much more tempered decision-making. And the reason is that the Attorney General is political. I think that independence is the evil here. What we need is someone who's totally embedded in politics. And I mean that in two senses. Tell me if you cannot hear me. Okay. You can't hear me? Okay. So the Attorney General is embedded in politics in two senses that I think are very important, and I think will bring more prudential decision-making in these areas. One is what Robert Jackson talked about in his famous speech about the extraordinary powers and danger of the prosecutor. He said one of the important safeguards of a prosecutor is the prosecutor was appointed by the president, confirmed by the Senate, and required to win expressions of confidence in the character of the person by the legislative and executive branch. So that's like a pedigree point that the Attorney General has that the special counsel doesn't. And then I think there's an outlook point. I think that the Attorney General necessarily has a broader outlook on the consequences of prosecution. It would necessarily consider broader factors than just the narrow focus on this defendant and whether I can nail the defendant. As Justice Scalia said in Morrison, almost all investigative and prosecutorial decisions, including the ultimate decision whether, after a technical violation of law is found, prosecution is warranted, that decision and those decisions involve balancing of innumerable legal and practical considerations. Decisions whether and how to prosecute are not algorithmic decisions. They involve enormous issues of judgment and enormous trade-offs, especially when you're going after the highest level people. So I think the Attorney General, if the Attorney General was in charge in making these decisions, would be more tempered in every direction. Here are two counterfactuals to think about. The January 6th, the classified documents prosecution of Trump strikes me as righteous and easy, and any prosecutor would have brought that. The January 6th prosecution is a closer case. It is a novel prosecution using laws in a novel way. It is the prosecution of the current president's opponent. There are many hard legal issues in this case that it's not clear how they're going to come out, including hard issues that could have terrible consequences for future presidents that the Justice Department also needs to think about. That's a tough decision. And what did Merrick Garland do? He delayed the investigation for a year, then he sped up the investigation, and then he got to the point where he thought that there was a problem. But then instead of doing all those trade-offs, all those hard trade-offs, he turns it over to a famously super aggressive prosecutor to let this person who has no accountability make that tough decision. I don't think that makes sense. Here's perhaps a better example, and this is a hypothetical example that we might face. When the Supreme Court rules on the Trump immunity case, there's going to be a question, depending on what the court says, about whether Smith will go forward with the Trump trial this fall. Maybe starting in August, depending on what the court says, maybe September. This is maybe the most important decision the Justice Department has ever made. The consequences are huge for the election, whether to go forward and prosecute Trump in September, and basically have him in September and October not on the campaign trail because the president's Justice Department has him in the courtroom and is not allowing him to campaign against the president. The norm of non-interference in the election, the implications for our broader politics, the implications for the rule of law if the president has broken the law, the implications of the possibility of even-handed justice, the implications for the Justice Department's reputation. I don't know how these different things play out. I don't think Jack Smith should be making that decision. I think Merrick Garland, for the reasons I stated, should be. Okay, I'm going to wrap up by just mentioning counterarguments or weaknesses or other things to think about. So it's possible that having the Attorney General in charge would just make the whole thing more politicized because he seems at the outset to be more biased because he's on the president's team. And if he's investigating the president, he might have an interest in protecting the president. And if he's investigating the ex-president, he might have an interest in hurting the ex-president. I think that's a close call. I think it's hard to tell. I don't know the answer to that question, but I'm willing to say maybe the decisions would be more politicized in our current culture. What if we had a really bad or biased attorney general, which we can conceive of having, which we've had in the past? This one I don't worry about so much because, frankly, the regulations are no protection against a bad or biased attorney general. These regulations are quicksand, full of loopholes. No attorney general ever has to appoint a special counsel. Or an attorney general could appoint a special counsel if the attorney general wanted. So I think that consideration washes out. Harder problems are, if the president's under investigation, I think the attorney general should run the investigation, be in charge of the investigation under normal Justice Department considerations. What if the attorney general is under suspicion? The attorney general clearly can't investigate him or herself. I think it should be the deputy attorney general or some other political appointee in the Justice Department. What if, as in Watergate, the entire Justice Department is under suspicion? That's a tougher one, and that may be the limiting case for even doing this. Maybe it would have to be a U.S. attorney who has been confirmed by the Senate and nominated by the president. There are very hard cases, even in a best-case scenario. But here's the final point that I'll leave you with. If the special counsel regulations, and this might undermine everything I've said, if the special counsel regulations went away tomorrow, it's possible that nothing would change. Because what's really driving these considerations is, and indeed, we had special counsels before we had special counsel regulations or laws for the same logic, and that logic applies more today. There's enormous political pressure when there's an allegation of a corruption or illegality at the top of the Justice Department to bring these investigations and prosecutions. We have a culture now of attorneys general who don't want to exercise what I think are their responsibilities that they should be exercising. They fear, because they're too hung up, in my opinion, on the independence and sacrosanctity and keeping DOJ out of politics. And so they have a natural inclination to want to shy away from taking these responsibilities. I think this explains a lot of what's going on. So, and there's nothing to prevent an attorney general from just replicating a special counsel process even without these regs. That's just the way it works. The regs ultimately don't do much work at all. So it could be that all of this stuff is just being driven by the logic of the politics of the situation, which is much worse now than it has been in the past. It could be that getting rid of the special counsel regulations would not have any impact on what I see as these problems. What you really need, in my view, are, maybe this is too strong a word, courageous attorneys general or attorney generals with backbone to exercise their responsibilities within the department to conduct these investigations. And although there are downsides to that, I think on balance, it would be a better world for DOJ and for our politics. Thank you. You want me to take questions, Michael? Questions?
I'll walk around with the mic. Jack, I want you to know that the frat party is in fact protesting your remarks. Just kidding. Sorry about the noise. They're not protesting you. But yeah, if you have a question, just raise your hand and I will come to you. And Jody will handle that side of the room.
Totally convincing.
Perhaps you already addressed this at the end of your talk, but perhaps if you just think of the regulations as a template, the political accountability is in the Attorney General, either with or without the regulations as you've described them, and that's the point you made at the end.
Yep.
So isn't the issue really not the regime of the independent counsels or the regulations as it exists right now, but the political strength of the Attorney General and his or her willingness to stand up in the political process? Part of this conference is about the unitary executive issue and the fact that the executive is responsible for this. Isn't this just a matter of the Attorney General acting as part of the political process?
Yes, I do think it is largely, it's a little more complicated than that, but yes, I do think, and I tried to suggest this at the end, that ultimately this comes down to the values and fortitude of the Attorney General and also, frankly, the President. The President could be directing all of this. The President can decide what kind of regime he or she wants with regard to these independent investigations. The President has ultimate control over all of this. Yes, I do think it ultimately comes down to the fortitude of the special counsel, but it's broader than that. It's also about the larger politics. Let me try to give this example. Bill Barr, not a man who's shy about asserting executive branch prerogatives in the Attorney General's office, and in fact, he's very proud of the fact that he has a broad view of the executive power, and he's happy to exercise it, and he thinks he's a vindicator of that view as Attorney General. He hated the Mueller report, and he had every basis under several points, every basis under the regulations to not issue that report, even though he had pledged he would, to Mueller one reason Mueller might not have made a prosecution or declination decision was because making a prosecution or declination decision was a prerequisite for the Attorney General for being able to review it. So it's not clear the AG was able to review that. In any event, Bill Barr, who's no shrinking violet, didn't think, for whatever reason, that he could do anything to change that report, even though he thought the law was wrong, he thought the prosecutorial decision was wrong, he thought Mueller violated various norms. So there's something, he's a strong Attorney General with broad views of executive power, and he couldn't do it. Maybe that issue came too late to him for him to have influence over it. I think it's harder than it looks, is what I'm trying to say. And it has to do with the larger political expectations that have developed. Does that make sense? That's the question. I mean, I think it's a dysfunctional system. Yes, I agree. I agree. But the question is whether Barr got the politics right. The question is whether Barr got the politics right. I completely agree that politics shape these decisions, but how the politics shapes the decisions doesn't make them the best, the optimal system.
Well, we really can't escape politics. So I'm wondering, because I actually come out to a similar place you come out at the end, which is this is a systemic problem and there are Band-Aid solutions. But if all we have are Band-Aid solutions, I'm wondering what you would think of reinstituting a filibuster for Department of Justice figures, so at least both sides, or at least each party, would have some sense that this person isn't a complete political hack.
Well, there's the giant loophole in that is the Vacancies Reform Act.
Yeah, no, but this is what I'm suggesting is if, given you're willing to get rid of a regulation, so would you champion for both sides getting rid and allowing filibusters for Department of Justice people, making rules that these positions could not be filled?
I think that as a general matter, I like supermajority rules in the Senate because I think it tends to result in less extreme and greater consensus candidates for confirmation. So I'm drawn to that for that reason. And in general, I think it would be, the Attorney General is such a vital, just such an important figure in the executive branch for the entire operation of the executive branch. Look, Merrick Garland, I don't remember what his votes were, but he was highly respected on both sides. And it hasn't helped him one bit. So, sure, it would be best if we could ensure having people of exquisite judgment and integrity in those decisions and fortitude. And so I guess all things equal, I think it would be great if we could change the system to ensure that. But what are you going to do about the Vacancies Reform Act? Because that's going to mean that it's going to be very hard to get attorneys general through, even if presidents nominate more middle-of-the-road, less controversial people. And it means that you might have the Justice Department being run by more extreme people. So that's a tough trade-off. Coming to you. You'll be next.
What I'm going to suggest is maybe heresy, but you talked, your first part of your talk was about the fact that having the special counsel under the courts was a bad decision for a whole series of reasons. But it seems to me your second half of your talk is basically we still have those same set of reasons, but now we also have more politics in it. And I'm just wondering, would it be possible that maybe we think about going back to the drawing boards and having it run through a court appointment to try to get some of the politics out of it? Because you clearly, from what you're saying, the amount of time, the budgets, under the old regime, we're still having that same problem under the new regime. So I'm wondering whether trying to take the politics out might be helpful.
So two things to that. One, in many contexts, the judicial appointments were seen as exacerbating the politics. The D.C. Circuit, I can't remember who the special counsel was that was originally investigating Clinton, but the D.C. Circuit, I think it was a conservative panel, were the ones that put Ken Starr on there, their old colleague. And that was seen as a political move by a totally unaccountable actor, and that was seen to be a disastrous. Second is, I want more politics, not less. I want these decisions made by someone who's going to take into account politics in the good sense. And so I'm not interested in having people who are outside of politics make these decisions.
I just wondered, it's a slightly preposterous proposition to put to you, I suppose, whether there's anything to learn from other countries, particularly other English-speaking countries. So I'm Australian, so was an Australian diplomat, so I'm quite familiar with the Durham inquiry and the Mueller inquiry.
Oh, right, of course.
In my country, we have the Director of Public Prosecutions and the DPP's office in the UK. They have the Crown Prosecution Service. So the Crown Prosecutor and the Director of Public Prosecutions are very much perceived to be completely independent people, and they're appointed for long periods of time, not for the duration of the administration that might be in power. And it does seem that the sort of controversies you have here over special prosecutors, the bias of the special prosecutors, and the perfectly obvious point, it seems to me, that you make, which is that the Attorney General is appointed by the President, so the President's not going to appoint someone who's inherently hostile to him or her. So that's all a given, the political bias of the system. I mean, it's an electoral system, so there is going to be political bias that's inherent in the system. But the DPP, or the Crown Prosecutor, is perceived by the public to be one step removed from the political process.
Can you tell me, so I don't understand the system, this might not even be possible in the United States. Are they removable by the Prime Minister?
Removable?
Yes.
No, I'm pretty sure they're not.
So we would need a constitutional amendment to do that. Part of the problem, the foundation, so I don't know if that system, I know that a lot of countries have true independent justice departments or true independent prosecutorial sections. That's just not an available option in the United States, at least no further than the independent counsel statute was, because the Constitution vests the executive power and the take care clause in the president, and so the president holds the prosecutorial power and has ultimate control over it. So that would, if it's functionally a good idea or not, I have my doubts. I know it works in other countries. I have my doubts it would work here, but I just don't think it's an available option.
I mean, the King has prosecutorial power in Britain and Australia. I mean, it's, in that sense, it's the same.
But is it
The Director of Public Prosecutions is appointed by the government when a vacancy occurs, but it will be for a period of 8 years or something.
But if the president doesn't, so we had a debate about this. Well, two things. If the president doesn't like what a prosecutor's doing, absent some very strange circumstances, the president can fire the prosecutor. And the president, and the court has made this pretty clear, has the ultimate control over prosecutions in the United States. Again, Morrison versus Olson and the independent counsel statute was a detour around that, but it hasn't grown, it's narrowed. Second thing is, after Watergate, there was a discussion about whether the Justice Department should be made an independent department, i.e. removed from the president, subject to very high for-cause removal, and whether that would be a good idea. And one, it wasn't clear it was not constitutional, but two, most of the people who testified on the right and the left thought that was a bad idea for our system. So that's what I'll leave you with. But it's just very hard to do given the nature of the president's powers, in my opinion.
So I really enjoyed this talk, so thank you. My question is about, I'm trying to figure out who your audience is for this policy proposal.
You're my audience.
Well, yeah, we're the audience in the frat party right now.
Yeah.
But it
I
seems,
don't have an audience for this proposal.
well, okay, maybe you'll have an answer though.
Okay.
So it seems to me that when the Attorney General appoints a special counsel, that in and of itself is a political decision, and it's a political decision that the Attorney General in that moment thinks that they would be better off politically if they were to somehow be at least seen as divorcing these as giving some buffer from political taint, for lack of a better word, from that decision-making process, and somehow protecting themselves. Maybe that's part of the calculus. And so my question for you is whether or not you're suggesting that the Attorney General themselves is making some kind of miscalculation, political miscalculation, and therefore should actually not be undertaking that, and or is just grossly irresponsible right? Or if what you're trying, if your audience is the public at large, to tell them, don't be mollified by this move, don't actually be distracted by it, it doesn't work, and then therefore take away the political benefit to the Attorney General by making that move. Does that make sense?
I think so, but I'm not sure, so let me give it a crack. I mean, I'm not really sure I got all of that. So wait, you might want to keep the mic there. I mean, it's not addressed to anyone. I'm trying to figure out the logic of the special counsel. Thank you. The logic of the special counsel, why it hasn't worked, where it's gone wrong, and why. And my ultimate conclusion is I'm not sure anything can be done about this. The foundational problem is the one I was just talking about. The president is in charge constitutionally in prosecutions, as is the attorney general, and sometimes they're under suspicion or their pals are under suspicion. That's just an extremely difficult problem for us to deal with, and we've been trying to deal with it and not successfully, and I'm trying to understand why, in my view, it continues to fail. I should add that I suggested that it's failed for 50 years, but again, it could have been worse if we didn't have that, right? So I can't say that that's not the case. So I don't have an audience. I'm not trying to persuade anyone to actually get rid of the special counsel regulations. But can you follow up? Because I don't think that's quite what you were asking me.
Well, I mean, if you don't actually want, if you're not trying to suggest that anything changed, then I guess I can remove my question. But I'm not sure I
Suggest
buy that.
anything changed. I don't think, I mean, who am I going to address this to get them to change? I'm just trying to figure out whether our country would be a better place if we didn't have this institution.
Right.
And I suspect that it would, but I'm not sure, is my ultimate argument.
Yeah, I mean, I think ultimately this comes down to whether or not you want to err as whatever we are, Democratic Republic. You want to err on the side of political impunity. We're going to err one way or the other.
Yes,
Are we
right.
going to err on the side of political impunity? Or are we going to err on the side of politicized prosecution? Right. And my view is that we should err on the side of political impunity, of impunity, rather than politicized prosecution, because I think the latter is much more dangerous, as we can see.
That's basically what I believe as well.
Okay.
And also, by the way, we have this part of the problem here is what was talked about yesterday. Part of the problem here is there are other institutions that are supposed to be performing this function. Congress, the press, the impeachment process, and the like. We were just talking about this last time. Those, especially impeachment, has degraded, which puts a lot more pressure on this alternate route to bring accountability to executive branch wrongdoing. And so...
Maybe if it didn't exist, maybe Congress would feel the need to step up.
Maybe. I think that's probably right.
Thanks. That was a great talk. I have a question about the history you gave of the special counsel regime since 1999. You told it as a history of failure. And another way to tell that history is that it worked okay for 15 plus years, and then over the last 8 years it has broken down. And there's a common feature to the last 8 years, and that
Donald Trump
has put extraordinary strain, whatever you
Yeah.
think about the political prosecutions or not, or the ongoing prosecutions or not, his presence has put extraordinary strain on the system. And so one way of understanding this is that no possible institutional design would have looked remotely good over the last 8 years, and so your comparator isn't the right one.
That's a fair point. Did it work? It worked well for the first 15 years because there weren't any prosecutions.
But there also wasn't anybody who was doing the stuff.
Maybe. There were a lot of prosecutions under... So maybe we had more virtuous officials. That's why there weren't prosecutions. That I shouldn't be worried too much about what's happening with Donald Trump because he's a one-off, and when he goes away, even though two of these involve the president and the president's son, those have not been wonderful examples of this working. It's quite possible that the whole thing is an artifact of Donald Trump, but then we have to ask, well, what's going to happen next now that we've had these experiences? How have these experiences with Trump and these prosecutions change? What's going to happen next? Are we going to have more tit for tat and the like, as we were talking about in the last panel? But it's a very, very fair point. 2 of the 5 have been Trump, and those have been the dominant ones. And he is an unusual character, I will grant you that, yes. Fair point.
This is just sort of a follow-up to the conversation that you and Beck were having, but I think it's, there's a sense in which independent counsel, special prosecutors, whatever, sort of crowd out the other actors, right? So if you think about like Watergate, think about the Senate Select Committee case in the DC Circuit, one of the reasons that the DC Circuit gives for why the Senate Watergate Committee can't have the tapes is that it would interfere with ongoing prosecutions, right? That it would have interfered with
That's a good point.
Jaworski and then Cox. I think you see that in a lot of subsequent cases as well.
You saw that in the Iran-Contra, for sure.
So in Iran-Contra, I think you saw it in some of the January 6th committee hearings where some of the witnesses said, well, we can't, we're not going to testify because there's an ongoing prosecution. So I think there's a real sense in which it's not just that other institutions can do this. It's that when you have the special prosecutors doing this, it actually makes it much harder for those other institutions to do the work.
Fair point, but a counterexample, the one that you talked about yesterday, the January 6th investigation was the roadmap for Jack Smith. They worked hand in hand. I know this for a fact. I mean, the first thing they did when they got going was to read those volumes. So it worked hand in hand there. And also some people think I'm not as up to speed on this as I used to be, that one of the reasons that Cox and especially Jaworski were able to have the public support they did was because Congress was on board with the parallel impeachment proceedings. There was an effort to get the grand jury materials from the grand jury materials involving Nixon. It was to Congress so that Congress can consider them for impeachment. So yes, it can be crowding out, but sometimes they can work together. Is working together like that a good thing? I don't know. Maybe it is. Maybe it's beating up on the president. Go ahead.
I mean, the examples of them working together are both examples where Congress went first, right? So to the Watergate example, you could add the fact, right, that it was the Senate Watergate Committee that turned up the tapes in the first place.
That's
right?
good.
When Congress goes first, the prosecutors can free ride on it. When the prosecutors go first, it seems to crowd out.
So that's excellent. So maybe that's the lesson. That so how do we incentivize Congress to go first? Those are nice points. We done? Thank you. No, it's totally fine.
Okay, great. One hand? No. Okay, there's steps on that side. Okay. Thank you very much. Okay, sure.
Thank you very much.
Thank you very much.